We're just getting everyone into the room right now, so if you bear with us, we're just doing permissions to add everyone into the chat, and then we can start. Okay, as people continue to come in, I'm going to start now. Hi everyone, and really welcome to this webinar today. I'm very excited to be moderating it today with some really amazing panelists. I'm Afsana Rigo. I am a senior program officer at Article 19, working on our Middle East and North Africa region. And I'm also currently an affiliate at the Berkman Klein Center for Internet and Society at Harvard. Just a note, I will be using my avatar for this session for some personal security reasons, but you don't need to be focusing on me anyway. You have three very nice panelists to focus on. I would really like to welcome you again to this webinar that's been hosted by the Program on Law and Society in the Muslim World, the Office for Clinical Pro Bono Programs, and the LGBTQ plus Advocacy Clinic at Harvard Law School. It's co-sponsored by the Harvard Law School Human Rights Program as well. Again, thank you all for joining from within the Harvard community and from across the world. I hope this is going to be a really useful and lively discussion. Just a few housekeeping notes before I start some of the introductions. Our audience will be muted throughout this webinar. So this Zoom webinar itself will be muted for the audience, but it'll also be recorded and made available with closed captioning after, and we'll put it on social media and hopefully have our own landing page with other videos around movement lawyering. We plan to have this session and the discussion with our panelists for about an hour and 20 to 25 minutes of Q&A afterwards. If you do have any questions or comments for the panelists, please do enter it in the Q&A box. We have our colleagues in the background who are supporting, who will take note and list the questions, and we'll try and answer as many of them as possible throughout, especially at the end of the session in our last 25 minutes. But you can submit your questions at any time throughout the webinar. So I'm really glad for us to be talking about this topic on movement lawyering today and having some amazing panelists who I will introduce to you in a minute. The context we're looking at today is Lebanon and the LGBTQ communities in Lebanon. I will leave the introductions to some of the context and situation to our panelists, but as many of you might have been following, Lebanon itself is going and has been going through multiple crises, especially in the last year, but it has been ongoing. Well, from the economic crisis to revolutionary protests to devastating Beirut blasts that have been really impacting communities and the whole country as a whole. And the way we will probably see in this session how advocacy and work, especially for marginalized groups, has been functioning. But without further ado, I wanted to introduce our really wonderful panelists today who I've had the privilege of working with and learning from in different capacities. We first have Tariq Zaidan, who is a sexual and bodily rights activist from Beirut, advocating for the rights and protection of LGBTQ individuals and groups in the MENA region. He's currently the executive director of HELM, the first LGBTQ rights organization in the Arab world, which was founded in Beirut in 2001. He is a Ashoka Global Changemaker Fellow, a Ford Foundation Global Fellow, an LA Fellow at Harvard Center for Public Leadership, and a Human Rights Fellow at the Carr Center for Human Rights Policy at Harvard. We also have the wonderful Yumna, who is a PhD candidate at the University of Paris Pantheon. She is a teacher and a researcher at the Faculty of Law in St. Joseph's University of Beirut. Yumna is also an attorney at the Beirut Bar Association and represents various cases with groups such as Legal Agenda. Her publications and research on gender, identity, nationality, family, personal status, and religious law. We also have wonderful Karim Namour, a lawyer, legal researcher, and activist specialized in civil and economic rights. And Karim is a contributing writer and researcher Legal Agenda and has been since 2010 and the member of its board since 2016. And Karim is also the host of Ganuni, a podcast that Karim has been running. I'm pretty sure I mispronounced that, but fix that later. So I really wanted us a little bit of background and context with the situation we're talking about, and understanding of what's happening in Lebanon right now and how that's impacting the work. I was wondering if one first importance of its inception and a little bit about the background of crises and how your work is.
Thank you, Afsani. You were cutting off, but I think I got most of that, and you were asking me to introduce Halim and my work. So first of all, thank you so much for this opportunity. And in order to be part of this really great event, we wish we could be there in person, but this is just as good. So Halim is an organization that was founded in 2001 and applied for registration in 2004 as the first ever LGBT rights organization in the Arab world. And it's the acronym means Lebanese Protection for LGBTQs, at least at its inception, but it also means in Arabic the word dream. And it constitutes three strategic pillars of serving the LGBTQ community in Lebanon and the region. We employ a services department that is designed to process cases, to do emergency intervention, particularly in cases of abuse, and provide all forms of psychosocial support for members of the LGBTQ community. And it sort of acts as a hub for all of our data gathering and evidence-based gathering on violations that are affecting the LGBT populations in Lebanon for our advocacy work. We also run a community department that is housed in Halim's Community Center, which is the largest and oldest non-commercial community space for LGBTQ people in the region. And before the Corona pandemic, would witness around 500 individual visitors a week. And also is the site where much of our power building and community-based work happens. And finally, our advocacy work, our advocacy department, which focuses a lot on sort of legislative policy and procedural reform across the board in Lebanon, particularly when it comes to issues of protection and issues of rights. The importance of Halim really has been that it has sort of acted as a catalyst for change for LGBTQ issues and gender and sexuality issues more broadly, because of the fact that it has a community-based and grassroots approach. In many ways, Halim graduated many activists that have gone on and done so many other programs, so many other institutions that focused on more sort of nuanced aspects of the LGBTQ rights movement. And that is sort of highlights the importance of creating spaces, brave and safe spaces where activists can come and build power together. And so it has been sort of an incubator for activism in its history, as well as still playing a very major and pivotal role in the major issues the major challenges that are affecting the LGBTQ community. Throughout its now almost 20-year history, the organization has been very malleable in responding to the needs of the community as they arise, which is something that's very significant given the rapidly changing socio-economic and geopolitical landscape in Lebanon at the moment.
Thank you so much, Tarek. Again, apologies, I just realized seeing the messages there, I was cutting off at the beginning. We'll hopefully paste in the introductions that I may have been cut off through with the video itself later. Thank you so much, Tarek, for that. I was hoping maybe, Yumna, if you can also give a little bit of a background around some of the legal context and some of the work Legal Agenda has been doing. So the attendees have a bit of a context of the work Legal Agenda does before we get into this as well.
Yes, of course. So Legal Agenda is a non-governmental organization that was established in 2009, 2010. The idea is to have a multidisciplinary approach of the law. And what we usually say about ourselves and about our work is that our goal is not to leave the law to the experts of the law. So the idea is to reconnect the law with this social and economic issues that underlie it, to show actually that the law is not only a matter of legal experts and legal opinions, but it is something that relates to the society as a whole. Our members are from different backgrounds. We are researchers, activists, lawyers, sociologists, economists. So we regroup a really very large scale of disciplines and expertise because of our multidisciplinary approach, and because we think that the law should not be left inside the courthouses and should not be left inside the parliament. It should be a matter of society, discussed within the society, and it should be reconnected with the real social and economic issues that it holds within it. And so our work, we publish a journal online and as a hard copy. We also establish lots of seminars where we discuss many legal topics, and we have many departments of strategic litigation, departments for drafting legal projects. We have worked on a lot of issues, from the independence of the judiciary to issues related to marginalized communities like refugees, LGBT, which is the topic of this session. I don't know if you would like me to give a legal context regarding LGBT issues in Lebanon at this stage, or if we leave it for afterwards, it's up to you.
Actually, that would be wonderful. That was going to be my next prompt there. If you can give a short outline of the laws and the legal context that does affect the community, that would be wonderful.
Of course. So when we talk about LGBT issues in Lebanon, the first article that we usually refer to is an article from the Criminal Code, Article 534 of the Lebanese Criminal Code, according to which the performance of intercourse against nature is punishable by an imprisonment that can be up to 1 year. So what the Penal Code or the Criminal Code refers to is intercourse against nature. For many years, most of the judges and most of the Lebanese courts have interpreted this article as applying to relationships between individuals of same biological sex. And they would apply this article without even having the need to justify why they would consider that any intimate relationship between two individuals of the same sex is contrary to nature, one. And two, they would even apply it sometimes even though there would not be any act of intercourse that would actually have been proven. So if two people were kissing, or if two people were found in any kind of an intimate relationship, even texting, courts would consider that this would be enough to criminalize individuals just based on the fact of their sexual orientation, and it would sometimes apply to people because of their gender identity. Furthermore, we would see that the judicial police within this context would usually practice lots of acts of torture, acts that could be qualified as physical abuse, moral abuse, and that would go even to anal testing, because people would get arrested, sometimes based on their appearance, sometimes based on the fact that they would be found in some kind of an intimate position with someone else, and interrogation would start without the obligation to have a lawyer present, because before the revolution, the law did not specify the need to have a lawyer present when a detainee would be interrogated by the judicial police. And people would be submitted to moral pressure and physical violence, and they would give a confession under duress, of course, and the judicial police would even go further, since they would even practice anal tests on individuals that were detained. And it is within this legal context, so the courts that would think that it is sufficient for two individuals to be of the same biological sex to apply Article 534 and condemn them to imprisonment or to a fine. Sometimes it would just be a fine, but it would even go to imprisonment in other times. And within the context of physical moral abuse, going even further, going to anal testing, that legal agenda started actually mobilizing before the courts in order to defend individuals that were arrested and prosecuted based on this article, and two, publicly, with the help of many partners, mainly HLM, but also Association of Doctors, in order to denounce the practice of anal testing. So we demonstrated how such anal testing were contrary, of course, to the law, how they were acts of torture, and most of all, we brought it up to the public, because part of our work, the work that we do with HLM, the work that Legal Agenda does, is bringing the voice of the people, the voice of the communities that are marginalized out of the scene, marginalized out of the legal scene and out of the public scene, to the public eye. And so this is when we started to campaign with the help of HLM and with the help of the Association of Doctors, to show what was happening inside of the centers where the detainment would happen, and showing and demonstrating that these were considered as acts of torture. And this resulted in the Medical Bar Association taking up a circular where it considered such anal testing to be contrary to the medical ethics, and the public prosecutor to give instructions to his judges not to continue practicing such tests.
Thank you so much, Jumna. I've been lucky enough to be able to at least look at some elements of this from the digital evidence side of things in what's happening in the courts and how Legal Agenda has been addressing some of these issues. So that's really an incredible insight to get into how that has been working more broadly within the organization. Karim, I was going to ask you here if there was anything you wanted to also add in terms of context in some of the work, especially that you've been engaged with at Legal Agenda.
Thank you, Afsani. Hello, everyone. I think Yumna pretty much covered very well everything that Legal Agenda does. I would only add maybe it's a shameless self-promotion that we also produce a podcast called the Kanuni podcast that I think you pronounced pretty well, Afsani.
Okay.
That's also part of our media production. I would add something to what Yumna said in a more broader sense when it comes to the general legal context in Lebanon, because in the following few questions, we will go more in depth in terms of what are the strategies and why were these strategies per se chosen. And to explain that, one needs to understand as well the legal and political context we dwell in, to understand the choices we've made. I'm going to try to make it brief because otherwise it can be an entire conference on its own. So basically, what we need to know is that the Lebanese regime is made up of a marriage basically between what is referred to by some scholars as the oligarchy, which represents a couple of political and economically empowered families who have been ruling this country for the last couple of decades in a form that is like a novel feudal system, basically. So it's a couple of families who own most of the resources in the country, who control the resources in the country, are part of the political system, either through political parties or by having their own political parties, as well as, that's the other side of the regime, a sectarian regime. So basically it is made up of this class system represented by the oligarchy, but as well by the sectarian regime. A lot of people may not know, but Lebanon is made up of a number of sects, 18 or 19, that are integrated within the system, not just as minorities, but also as basically religious groups that have that are recognized by law, that whose own laws are applied when it comes to personal statuses, when it comes to marriage, for instance, or divorce, or even inheritance. So this is very important to note because it shows a little bit what little things can change within the system, because it's a very rigid system that is very tough to break. The revolution that started on October 17th, 2009, we're celebrating the first year anniversary in a couple of days, rocked a little bit the cradle of this regime, but did not break it. So to explain also why for the last at least decade, we've been focusing more on the judiciary, is because the parliament, the government, so the entire legislative and executive branches of government are really controlled by this oligarchy, by those political families, and by the sectarian system that is very tough to break. However, the judiciary, on the other hand, is made up of people, of judges, more than 600 judges distributed across the country. And what we try to build through that, and this is one of the main reasons why Legal Agenda was focusing so much on the independence of the judiciary, is the fact that by targeting judges and by communicating, basically trying to generate a debate within the judiciary, we can also produce change. We can also sort of encourage this novel form of democracy that I will speak about later in more detail.
Thank you so much. That's a really important context to keep in mind when we move into the frameworks we've been talking about, we'll be talking about in terms of movement lawyering. I wanted to move into the actual main part of the discussion around movement lawyering and called advocacy and lawyering. Tarek, Helen has been working with Legal Agenda lawyers and their legal teams for a while now. Can you give me a little bit of an outline of how this collaboration started, how it supported your work, and how your work has supported them?
Yeah, sure. I think one of the reasons why the collaboration and the work between both Hilm and Legal Agenda has been so successful is that, first of all, both of organizations share a commitment to the independence of the judiciary and the importance of the rule of law as a foundation of democracy and any future state building project. And considering the judiciary, as Karim said, is one of the few places in which you can have conversations that were otherwise impossible to have in other parts of the Lebanese government and other parts of the Lebanese public sphere, it was a natural sort of alliance to happen. But in addition to that, the way that the Legal Agenda approaches is that it recognizes that reform, particularly legislative or judicial reform, doesn't necessarily take place, or indeed cannot only take place in legislative and judicial circles. There needs to be a systemic way of approaching change and approaching reform inside these spaces. And that's where it carves a role for organizations like ours that are grassroots, that are community-based, and that are very strategically community-based in order to ensure a sustainable response and a sustainable movement that plays the long game. And so that combined created the infrastructure, sort of the values and the strategic infrastructure for our collaboration. And then in addition to that, the lawyers of Legal Agenda, two of whom are my panelists, my co-panelists here today, have developed an expertise and experience in dealing with LGBTQ issues and gender and sexuality, take account local laws, local legal customs that were otherwise not available to us in the global south, and particularly in the Middle East. So this knowledge that was created, which later culminated into the first ever model defense for Article 534 that was published jointly between HLM and the Legal Agenda, was really a new original piece of work that we didn't know and we couldn't find before. So it was very obvious that they filled a much needed gap in order for us to start building power, in order to protect members of the community from the assault that was being held upon them by the judiciary, by the security apparatus, and by the government as a whole in Lebanon. And this collaboration culminated in not only in really effective change that is across the spectrum when it comes to the public sphere, the civil society sphere, the educational sphere in Lebanon, but also in several cases that were won by Legal Agenda lawyers that were among the first in the region, if not the first in the region, that chose not to criminalize LGBTQ people in accordance to any of the articles in the penal code, and to rethink these articles and sort of create a new jurisprudence within the judiciary. So it was a very natural and continuously successful partnership and collaboration.
It's really wonderful. Thank you, Tariq. And it's a really important outline of how this sort of movement lawyering needs to be done from a grassroots perspective to bring in this sort of institutional change and understand what is necessary. So that was a really powerful way of starting this conversation. Our panelist, Karim, has had some connection issues and he'll be back on in a moment, but I wanted to pass the next question to Yumna, especially because Karim mentioned the model legal defense that was created between HLM and Legal Agenda. So in our conversations and in the work that you've been doing, especially within the trans communities, it's been really groundbreaking and absolutely vital. And you've done this through centering the voices of the community you represent and working directly with individuals and community members. I remember you once told me that if you're not employing movement lawyering in this type of work, I don't know how you achieve anything impactful. So I remember that very powerfully. I remember I wanted us to talk more about movement lawyering here. How do you see your role as an expert when it comes to breaking down these issues relating to client-lawyer power dynamics that's impacted your work? And how is that impactful when it comes to your work and assisting the community? And after that, now that Karim's back, we'll go and talk about the strategic litigation and your model legal defenses too.
Perfect. Actually, when you look at the judicial scene, and when you begin practicing and right out of the law school, and you begin going into the judicial scene, you begin entering the courthouses, etc. The first thing you notice is that the judicial scene is a very violent place. It is a violent place to people and individuals that are not part of the legal professions. And this violence, you see it physically, because there's a lack of access, of physical access to the courts, to the judges, even to the judicial police and to the precinct if you are a victim of some sort of crime. And it is also a verbal and moral violence because you are not heard, especially when you come from a marginalized community. And this you will notice even in the language that is spoken. We know that there is a legal language that is put there and that actually alienates whoever is not a part of the legal profession. And so when people come from outside the legal professions, it is very hard for them to be seen by the judges. It is very hard to them to be heard by the judges. And sometimes when we start as lawyers, we have a tendency to adopt this way of doing things, not hearing our clients, not seeing them, not hearing what they want to say and how do they want to express themselves. So the way I see my job and the way I see my role is breaking down these obstacles. My role is actually to try and understand what my client or my clients want, how they see themselves and how they want the courts to see them, and to push actually for the judges to hear their voices and to hear what they have to say and to see them. And once actually you get to, if you are victorious in breaking down these obstacles, mainly the language obstacle, and you get the judge to see and to understand what we are talking about and what your client is living and going through, half of the battle is won. And this is how I see my work. And this is the work that I have been doing with the trans community and with Tarek. So it was very essential for me when I started working on issues that transgender individuals would face within the law, to hear what they had to say, to hear how they wanted actually, what they wanted to say to the judges, and to start discussing with them how this can be translated legally. I remember I had a case where a lot of people, 8 women actually, were arrested, 8 trans women were arrested. And the only thing that was in the minutes that have led to their arrest was the fact that they were trans women. The police said that they suspected them of prostitution, but there was no element in the minutes saying that there was anything that has led the police to believe that they were practicing prostitution. They were only arrested based on their appearance. And this I understood when discussing with my clients. And when my clients said, we don't understand why we were arrested, we discussed how they should express this in front of the judge so that the judge understands what actually happened, that they were arrested based on their appearance and based on their profile. And this already, when we started the hearing with this exclamation and with this affirmation that wasn't done by me. I didn't say it because I didn't live it. It was my client that have lived this. When they said it and when they expressed it in a language that the judge would understand, in a legal language, but also coming from a livelihood experience, this had set the tone to the hearing and to the whole court process, and they were acquitted at the end. So it is very important actually to listen to what your client has to say and to listen to what they want to achieve in front of the courts. It's the same thing when we talk about gender identity, because some people would like to think that this is we are talking about medical problems, or because this is how a part of the Lebanese society views this, and some judges would have these preconceptions. But it is also important to let actually your client express themselves in front of the judge to explain what is gender identity and what is the concept of gender and why we are going to see the judge to ask for a change of sex, etc. This is actually what makes it progress, because it makes judges actually question the way they were seeing things and listen actually to what people have to say and taking into consideration their issues. So the way I see my role actually, to just wrap it up and answer your question, is actually bringing the voices of individuals, my clients, and particularly marginalized communities into the legal sphere, into the legal scene, to get them to be seen and to get them to be heard. But in order for me to be able to do that, I should see them first and I should listen to them first and use my legal knowledge to translate what they have to say legally into legal arguments.
Thank you, Yumna. That's like a really incredible breakdown and example of how movement lawyering should be done with centering of the communities who are experts in their own experiences and needs, and how to break down some of these paradigm dynamics that communities become faced with. I especially love the points around breaking down the barriers when it becomes to technical linguistic barriers that the law in itself by creation and application places. So thank you. I wanted to move on and on that note discuss a little bit about the strategic litigation methods you take on within legal agenda. We've spoken about this a little bit, Kareem, within the interview I did with you, and from the work I know of legal agenda. Your work in using strategic litigation has been very important and impactful. Can you tell us a little bit more about the work in using this strategy, especially when it comes to tailoring the strategic litigation between grassroots groups such as HELM to push for greater legal rights for marginalized communities, and how you really decide which courts are appropriate for this forum, whether courts are appropriate for this forum, and how you go about developing this litigation or advocacy strategies with the communities you work with?
Yes, absolutely. Actually, I'm going to go back a little bit to what I spoke about during the introduction, relating to how the governmental and executive branches of the government were inefficient for so many years in terms of improving laws, etc. Yumna spoke a little bit about Article 534. So to give a concrete example on why we chose the judiciary instead of another platform, I'm going to vulgarize this. Article 534, as Yumna mentioned, criminalizes any carnal conjunction against the order of nature. So this is basically any intercourse that would be considered against the order of nature. From the text of Article 54, we can clearly see that the text is very vague. Who amongst us can say what is or is not against the order of nature? So this is something that we can really argue, that we can really debate. However, when this text was actually proposed, I mean, a proposal to amend the text was presented to Parliament back in 2000. Back then, there was Rafiq Hariri was still Prime Minister. His group and his political group said, oh, it's vague, so we need to specify that it should target homosexuals per se. So this just shows how much it can be twisted to work with Parliament, because when you are working with parliamentarians and with politicians, you're not really working on a rational level. You're working sometimes on a very populist, sectarian-based, prejudice-based level. So choosing to go with the judiciary, and to add to what I already mentioned before, is because this would allow you two main things. One, to rationalize the discourse, to rationalize the debate, because judges are formed to structurally answer your arguments from a legal perspective according to legal procedures. So you already have a frame in order to really cater and to basically limit to what extent the debate can go. So you wouldn't receive populist or irrational or religious-based or prejudice-based opinions. Judges are forced to think the law, to think arguments, and to come up with answers, even if they don't agree with you, to come up with legal answers in order to respond to your arguments. So this is one of the objectives. The second objectives, and I'm going to build on what Yumna just said, because this is really one of the major objectives of strategic litigations, because as lawyers know, we don't always win the cases, and sometimes the objective is not to win the case. The objective is to highlight the narrative of the person we're defending, of the marginalized group we're defending, etc. So the judicial platform is the ideal platform for highlighting this narrative, because it's a public one, it's an official one where narratives are written down and left as archives to be referred to later on. So it's very important to actually use that platform. That's one. Two is knowing how to target it. So I'm going to go into more details into what the mechanism of strategic litigation works, what type of courtroom you want to choose. Because again, we were speaking about this, you and me, and I was speaking about this with Yumna a couple of hours ago. The difference between legal aid and strategic litigation is that legal aid, you don't really choose the type of case. The point of the legal aid is to actually just ensure representation happens before court. Strategic litigation is completely different, because what you're looking for is to push for a cause, to defend the cause, to generate a given right, to improve the law, and use cases, court cases, in order to do so, to generate that debate with the judge. And you remember I spoke about the novel form of democracy. This novel form of democracy basically takes shape with four major components. So the first one is the judge themselves. Second one would be the lawyer. The third one would be the defendant, the plaintiff themselves. And the fourth one is the media. So these four components would basically create this novel form of democracy, where issues that are not being tackled by the legislator are tackled by the judiciary. And law improvement can happen through the judiciary. This is true for LGBT rights, and we're speaking about this right now. This is true also for a number of other causes. I've had a chance to defend persons who use drugs, or families of the disappeared during the Civil War, or environmental causes. All of these issues, and specifically those concerning marginalized and vulnerable groups who usually are not given space enough to share their narratives, are actually used through strategic litigation for these different purposes. To go a little bit more in detail, and very, very briefly, because we're short on time, also one of the approaches in strategic litigation, and you already spoke about this, is how you choose your client. So it's not just the courtroom, it's not just the judge, it's also the client. The client and the defendant in a strategic litigation is not an accessory. They are really part of the defense team. And here, the role of the lawyer is completely different from other cases, because it's not a top-down approach. It's actually a very horizontal approach. Yumna spoke about being working as a translator, translating the narrative of the victims at the courthouse, but it's also the other way around, because she spoke about the violence of the courtroom. So the lawyer also works as a translator of legal procedures of the law to make this more accessible to people who don't necessarily have access to a courtroom, or don't necessarily have access to the legal jargon, or understand what the procedures are. So to make the client basically part of the defense team, you need to really empower that client and that defendant through information. That's one. Two, you need to empower them as well in the decision-making process. Because again, you're not working as a lawyer defending someone, you're working as part of the team. And here I like to think of lawyers as team leaders rather than lawyers defending a client. So this is usually really taken into consideration. We can go back to it in the last question. I just want to finish on that note, because Yumna spoke about it as well, is two things. One, the fact that in order to understand the community, there's a prerequisite in studying that community, in actually organizing sessions with a given community, be it the LGBTQ community, or be it the families of the disappeared. Sessions that are either know your rights sessions, so where the lawyer plays the role of the translator of the law and of legal procedures, but also very informative sessions to the person defending these communities, to understand them, to understand their concerns, and to actually be able efficiently to translate and to transmit their narratives before the courtroom. Finally, the anal probe issue, Yumna spoke about it. This is also a strategic choice. When we were having a great difficulty to make the LGBT issue part of the mainstream discourse and the mainstream media, the anal probe scandal happened. The anal probe scandal actually was when we decided to highlight this and to defend it and to try to abolish this practice. It was also a strategic choice because it took the debate outside from the very narrow community debate of LGBT rights and made it into a broader torture debate. So more people were able to actually identify or to actually sympathize with the cause, because the cause was not just about one specific community. If the torture happened to that community, it can also happen to me. And people started becoming more engaged in it. And this is how we actually successfully were able to abolish this practice.
Thanks so much, Kareem. That's really important outline. I wanted to, before we go on to the model legal defense, which is the continuation of the strategic litigation discussion we're also having, I wanted to actually jump to Tariq here to, one, ask you about the importance and the changes that came about with some of the landmark cases through some of this strategic litigation work, but also to have some sort of framing and discussion prior to us continuing a little bit more about how the changes, you already like addressed some of it at the beginning, but how after the Beirut blast, the financial crisis, and the recent what's going on with the COVID pandemic and the crisis and the revolutionary movements, how it's impacted the way you're going to be looking at, and you have been looking at, things like litigation and supporting the community and the intersecting social, economic, and legal needs of that is affecting the community right now.
Sure. So it has been a very eventful year in Lebanon. For the past 12 months have been in cataclysmic in many ways. And, you know, we right now, 12 months after the advent of the Lebanese revolution on October 17, are quite honestly in a different universe. And the process of thinking of how does activism, particularly community-based and grassroots activism, respond to this post-COVID world and also to this new geopolitical reality in Lebanon is an ongoing sort of concern for us. But let me tell you that, you know, I at least consider, we at Hilm consider the October Revolution to be Lebanon's first ever pride parade, and really the region's first ever pride parade, because the October Revolution was unprecedented in terms of how much the queer community was active and visible in it. And what was really interesting to see is that it was very much a women and queer-led revolution, and men, interestingly, was more either irrelevant or the villains in the revolutionary narrative, if one is to remember those times 12 months ago, which seemed like, you know, 12 years ago at this point. But what was interesting was that the participation of the queer community was done within the framework of asking for rights that were not LGBTQ specific and were not civil and political in nature. People were on the streets demanding economic opportunity, end to corruption, social security. And this was really important in understanding the trajectory and history of the LGBTQ rights movement in Lebanon in particular and in the region, and also in understanding how fundamentally different these movements tend to be, or perhaps ought to be, than what we're used to in terms of the trajectories of the movements in the global north. Just like in our part of the world, it's not easy to compartmentalize LGBT identities. It's also not easy to compartmentalize LGBT causes. I'll give you a precedent to this. The first time that the rainbow flag was ever raised on Arab soil was in Beirut in 2003 during a protest against the Iraq war. So this sort of intersectional way of working has long been something that is part of our DNA. And in many ways, the advent of the revolution and then the subsequent economic and political crisis did a sort of a vindication for our work at Hilm, which, because we had, you know, several years prior began diversifying and really seriously considering social and economic rights as an equal framework to achieving liberation for the community in tandem with civil and political rights. Here, my colleagues mentioned the centrality of freedom of expression, whereby the arresting officer would arrest individuals based on his evaluation of the way they looked and dressed. as opposed to the fact that he had any evidence that any sexual intercourse had taken place. My colleague Karim is an expert on labor rights, and we've been working for a while now on reforming the labor law in order to be more inclusive of LGBT people, but at the same time also approaching and doing work on workplace equality, because because approaching the issue of discrimination and violence in the workplace is also something that you need to engage the private sector in and the public sector in, not just reforming the law. That doesn't work in and of its own. So this was the way we were working. The Syria crisis that had witnessed an influx of Syrian LGBTQ refugees into Lebanon also had a fundamental impact of how we thought about liberation, how we thought about protection of LGBTQ people within Lebanon itself as a whole. And then, you know, the COVID-19 pandemic happened, and the subsequent lockdowns, also the economic crisis and the political crisis, and then finally the devastating blast of August 4, which unfortunately was around 700 meters away from the Helm's center, which was in the heart of the most LGBTQ friendly area of Beirut, which was devastated in the blast. And all of a sudden we found ourselves facing a whole new slate of challenges that were not previously something that we had prepared for, including, you know, rising food insecurity, particularly nutritional hunger, mass evictions and homelessness, unemployment skyrocketing, lack of access to any form of healthcare, and, you know, sharp spikes in domestic violence and in violence against people on the street, as opposed to what we were used to before, which was violence from state apparatus and from security apparatus, and of course an acute mental health crisis that people don't seem to be recognizing. So we quickly noticed that it wasn't just sufficient to engage with the issue of LGBTQ rights purely from a human rights and from a legal perspective. You also had to consider a development framework. You also had to consider multiple angles with which to solve this public problem, which goes back to what the legal agenda's sort of founding values and vision is, which is not just an organization that works on the law, an organization that looks at a problem and tries to solve it systemically. And this is where our work has really become very important and quite unique in attempting to solve these problems. The last thing that I will say is that when it comes to really looking at the issue of LGBTQ rights now, you cannot ask yourself, how do I reform an institution in order to become LGBTQI inclusive? The fundamental question must be, how do you serve and improve the lives of LGBTQ people? There must be that form of malleability and tensility in your understanding of how to solve the public problem, which must include the law. It must include legal reform. It must include engagement with the judiciary and with the legislature, but it cannot be sequestered to it alone. And so as we're moving to this new era, as we're moving towards the reality that Lebanon is now a poor country, that Lebanon is now a country that has a completely different infrastructure with which to think about activism, where you are in a COVID pandemic in which the community can't physically come together to build power. So how do you solve these problems? It is really important to maintain this intersectional and diverse viewpoint into solving the issue of LGBTQ rights and discrimination in Lebanon. And that's where I think we play the pivotal role and are also a place where we can think about these issues from a very sort of global South and particularly Middle East perspective.
Thank you so much, Tarek. And again, this was such an important point to talk about the intersections of how we're trying to build power. And also just to say, I'm so grateful for the work that Helen does in bringing these notes and to bringing this sort of understanding and expertise even beyond Lebanon itself. I wanted to go back to some of the strategies that we're using and discuss the model legal defense that we had mentioned earlier. I remember doing an interview with Rida Fangia, one of your colleagues, and I remembered a note that Rida made, that she mentioned that the legal defense itself is a very democratic legal tool of advocacy and defending queer people and people in general. I wondered if Yumna and Karim, hopefully maybe we can start with Yumna, if you can give me a little bit more about the model legal defense and how you created it, and how this was done in collaboration with the expertise of groups like Helen.
Yes, well, the model legal defense was developed by Legal Agenda in collaboration with Helen. It was developed by Rida, who worked on it extensively. And well, the main issues when you look at the model legal defense, you will see that it tackles all kinds of arguments that could actually be opposed to a lawyer in a case based on Article 534. So this is how you see that it is the result of the work that has been done with Hilm and with the communities, with the affected communities, because you cannot know just by being a lawyer without having a case in front of you what are the arguments that could be used against you, or what are the arguments or preconceptions that the judges have when they want to think about criminalizing a person just focusing on Article 534. You can use, I mean, the history of the court decisions, but like we have said before, judges didn't even think that it was necessary to justify why they would consider that same biological sex relationships were contrary to nature. So what we took was what was being felt, what was being addressed to, and what was being lived by the communities, what arguments were they faced with, what they were living, in order to develop, based on this, the legal argumentation that would attack and tackle each and every issue of the model legal defense that would address every preconception that you could find in the spirit of a judge when being asked to apply or not to apply Article 534. For example, the issue of knowing if same biological sex relationships were contrary to nature or not. One of the many arguments that was being used is that, well, if a relationship, if a sexual relationship does not lead to progenitor, to having children, it should be considered as contrary to nature. And one of the ways that we have addressed this issue is not just by using arguments from scientific arguments, etc., but it was also by getting the judges to identify with what we were saying. By saying we had a panel of judges, for example, of women judges. We had 2 judges out of 3 judges. It was a majority of women in the panel of judges. So we took actually the example, we made it known to the court that the legislator had considered that selling contraceptive means was not illegal, and therefore was considering that any relationship that would be done by a man or a woman that does not have as an objective having children is not contrary to the law. And we took as an example the example of a woman that is going into a pharmacy to buy such contraceptive and saying that this is today possible in Lebanon. Every woman can do that, choose to have a sexual relationship, not having as an objective to have children, and buying contraceptive from the pharmacy. Why did we use this? Because we wanted the judges to look at us and to look at our clients as they look at themselves. It was very important to actually tackle this issue that was always being brought up when someone would address anyone from the community, telling them your relationship is not normal because you cannot have children after a sexual relationship, biologically have children. And so it was very important to tackle it in front of the judges, because what the client lives is what happens in the minds of the judges. And so this was very important. Another part that was important, and I'm going to wrap it up on here, was you use the model defense taking into consideration what are the judges, who are the judges in front of you and how they think. When we were in front of the Beirut Court of Appeal, we knew that these judges were a certain generation, and that the main concern was, are we actually imposing Western values, or are we talking about values of our own society? And this, it was very important to demonstrate to the court that we are not coming from abroad. We are not lawyers that are coming here with international human rights principles, etc., that we are trying to impose as a Western culture in Lebanon. That no, actually, we are working in Lebanon. We come from Lebanon. Our clients are from communities in Lebanon. They are in the public spaces. They express themselves. They are here. And showing to the court that these are not Western values, these are our values. And to be able to show this to the court, it was very important to have the supporting experiences of our communities, that, like the work that Helen does, being present, being visible, to show that we are Lebanese, we are not coming from the West, and that the Lebanese culture is not one culture, it's a multiple of culture that should be recognized legally.
Thank you so much, Shimna. That's a great outline, wonderful outline. I think something like a model legal defense, and hopefully maybe in the chat we can add a link to it, because I know it's public, this model legal defense that's being created. I also think about it from the standpoint that, and I know from my conversations from both of you and in different countries in the MENA region, individuals don't always get the best lawyers when it comes to supporting community needs and movement needs, and having a model legal defense even in these situations provides some of the lawyers that might not have that sort of expertise of fundamental framework of how to move these cases forward. So something like the model legal defense has been created by Legal Agenda is really important. And I do remember Rita mentioning that even judges in Lebanon had used them in some of their understanding in passing some landmark cases. So thank you for that. And just in terms of time, and I know we have a few questions, I thought instead I wanted to ask you, Karim, to maybe talk about, and actually all of you to maybe talk about and provide some few pieces of advice to folks, whether it's students or whether it's international organizations or whether it's just anyone trying to get involved in movement lawyering, and how they can start doing that, and how they can start getting involved with this kind of community-based approach, and what sort of balance is needed. How does that approach even start and commence? I know we have a question on this later, so we can direct that about students specifically, but with this note, I kind of want you to also make a note really about the issues when it comes to parachutism and how people shouldn't be parachuting into these concepts, and how they can be doing it impactfully and respectfully within the contexts.
Absolutely, actually. So we already a little bit spoke about this during the second point. Basically, what one needs to do from the very beginning is two things: understanding the community and understanding the legal context. Without this, the work can be absolutely disastrous. And in order to do so, what we need to do is like we did when we drafted down the model defense, first understanding the legal context. So basically we studied what were the decisions that were issued by the various courts in Lebanon, to understand what were the prejudices in order to build strong arguments on this. Two is actually sessions with the community themselves, understanding the community you're working with. Again, this is not a top-down approach. In strategic litigation, lawyers and defendants are part of a team. And in order to be part of a team, everybody has something to contribute. Lawyers are absolutely, it's a must, need to understand the community, the concerns of the community, the narrative of the community. And not just speaking about LGBT, the queer community here, we're speaking about various marginalized groups. A lot of them lawyers may not identify with necessarily, so they need to understand what their concerns are and try to tackle that. In law school, we're not really taught how to manage clients. We're taught how to analyze the law. We're taught to be technicians, basically. So there's a lot of rewiring that needs to be done. I'm going to give an example of when I worked with the families of the disappeared. So you have people who are traumatized by the disappearance of a family member or kin. You cannot come to these people and interview them. So when you first meet these people, you basically go through an interview to understand how it happened, to gather evidence, etc. You cannot come to those meetings with a ready-made questionnaire. You need to have to know this questionnaire by heart, but you need to go along with their narrative and then try to gather the information you want, but in a very soft sort of way. A very simple example, just to give a concrete example of what I mean. You need to match basically your audience. So as a lawyer, you wouldn't go wearing a suit when you are trying to defend farmers. You need to also match them on this level in order for them to identify with you and to be able to open up with you and talk to you. So this is, I think, one of the most important advices, because when we first started working in this field, particularly not as lawyers, as socioeconomic rights defenders, etc., you come into this field with very good intentions and you really want to make a difference and you really want to try to understand communities and defend their interests. However, you are immediately shocked by the realities of how things function, the discrepancies between the judicial world and various communities on the ground. And this is something, again, we're not taught in law school, we're taught in practice. What I would advise is to actually study, to read, to study the communities, read the context, understand the context, and don't come into those meetings with the lawyer's framework. Come into those meetings as a team leader, as someone who is part of the team, in order to basically push and improve laws accordingly.
That's fantastic. Thank you so much. And I think these are such important tools in understanding how to get engaged and start working in movement lawyering, especially because I understand it becomes pretty overwhelming for a number of people that want to get involved, not understanding how to do it properly and feeling like they might do harm, which is, I think, a good initial mindset to have when it comes to self-reflection before being involved. As you mentioned, good intentions aren't always enough. And I think we're going to move into the Q&A to bring up some more of these issues. So I'm going to go to one of the first questions that is for Tariq. To what extent do you have allies within the political and legal systems? I'm particularly asking about people power that your efforts can target and leverage beyond the grassroots communities that you conduct work with on the ground.
Well, thank you for the question. It's really the million-dollar question, which is, you know, who in power is going to adopt this cause and sort of facilitate, you know, access to a much sort of a more fair penal code or anything like that. To be honest, it's a lot more complicated than that, because as Karim mentioned in his introduction, the political establishment in Lebanon has long been complicit in the marginalization and discrimination and disenfranchisement of LGBTQ individuals. So that's why the October Revolution was so important, was because it heralded in and introduced new political actors on the scene that we as a community were both able to engage with and in many cases already intrinsically a part of. So literally we were building power from scratch. Sort of trying to find existing allies within the political establishment within Lebanon, A, has been notoriously very difficult, and B, is fundamentally also a betrayal of the way we do work at Halim. All of the political parties involved have been in one form or another you know, complicit in the discrimination and in the disenfranchisement of our community. And so therefore, we see the way to sustainable long-term change as us being part of this new, in this case, national, but not necessarily, relegated inside Lebanon's borders, this new narrative, this new public narrative of Lebanon, this new understanding of politics, and actually the birth of Lebanese politics. If Lebanon is a small country, it's constantly at effect rather than at cause. I can argue that Lebanese politics aren't argued in Beirut. They're argued in Washington, in Brussels, in Tehran, in Riyadh. They're not argued in Beirut. And the revolution did something new, is that it brought politics back to the capital city by people that were trying to start something new, a completely new public narrative of the country outside of the narrative of the sectarian elite. And so that is where we are trying to build power. That is where our allies are. And all of these new actors, these new political coalitions that are emerging, all of them have, have sort of LGBT inclusive policies. All of their platforms suggest a complete removal of Article 534 and the other articles in the Lebanese Penal Code that specifically target LGBTQ individuals. They've been very open to speaking and collaborating with grassroots organizations like HLM and other, a myriad of other organizations on the ground that are working on rights-based and identity-based issues. So that at least is our understanding of what it means to build power in a political way.
Thank you so much, Tariq. That's wonderful. I really want to try and get to as many of the questions as possible. I think I'll go to one question that Karim has started answering, but we can get into more from a student perspective. One of the questions is, I am a student who is starting to explore movement lawyering in Lebanon. So my question is that, what are some of the recommendations you have for how I can initially get started or get involved with movement lawyering? Yumna or Karim, whoever would like to take.
Yeah, actually what I wanted to say regarding this is that when you do movement lawyering, you go to the individual. The individual doesn't come to you. So you have to go to the individuals. How do you do that? You do that through grassroots movements. It means that you introduce yourself to organizations that are grassroots organizations, just like HLM, just like I did with HLM. You introduce yourself. You start actually understanding what they are doing, listening to their needs, and offering what you can do actually to answer these needs. This is how you go for it actually. You cannot sit in a law firm and expect to do movement lawyering while sitting in a law firm and waiting for the people to come to you, because that is not the right approach. The right approach and the goal of this is for you to go to them and you adapt yourself to their needs and to their time and to their conditions, to the conditions that they are living within. Like I remember with HLM, or when we talk about HLM, I would go actually, we would organize sessions in the community center with Tara. We would go sometimes very late at night to do these sessions, and we would wait for people to come. Sometimes people would be late, but this would not be a problem. So you have to leave excuse me for saying this, but the legal arrogance at the door. You cannot come with a legal arrogance. You have to go, you have to listen to what they have to say, you have to adapt, and you do that by going to the grassroots organizations, listening to what they are doing, understanding what their needs are, and developing your capacities in response to those needs and in collaboration with those needs.
I would like to also just add something that I think is really important, particularly when people are approaching movement lawyering, is that just taking this issue into account, do not underestimate just how much is built based on the gender binary and built on this sort of heteronormative understanding of history, and how much it is ingrained in a certain culture, and how much judges particularly are custodians sometimes of the values of a certain place. So when you're doing movement lawyering, it's not just about the legal technical arguments, you're also going up against a value system that is there that you're trying to shift. And shifting values is incredibly difficult. You must think in a systemic way. The reason why the legal agenda in particular is so effective is that not only does it have, prowess in understanding the law and understanding the community, but that its lawyers think politically. They don't just think as lawyers within a court case. You must understand not just the history, but how to leverage other battlefields outside of the courtroom in order to move the entire movement forward. Pardon the repetition. You must understand media. You must understand your allies and your adversaries and how they operate and sort of play off one another. One of the things that I've noticed in how successful the lawyers have been in changing the judiciary in Lebanon is that in the arguments, they don't just argue the specifics of the case, but they, in many cases, implicitly and sometimes even subliminally suggest a new role for the judge and understanding the judge's role in protecting individuals, in protecting minorities in particular, and ushering a new jurisprudence within the judiciary concerning gender identity and sexual orientation and gender. That is what makes it sustainable. That is what makes judges really understand and not just make one sort of ruling, but then go on and become advocates themselves because they found a new way of thinking about things rather than just isolated in one case. And you must know how to play all of that. It's not just it's not sufficient just to know the inner workings of the model defense. And so this multidisciplinary approach is necessary if one is to think about movements rather than just individual cases.
I see you're unmuted, Karim. Did you want to add anything in there?
Yes, I just wanted to basically add to what Tariq was saying in terms of one of the strategies was to highlight judges that issued landmark rulings in that regard, because it also created a support to those judges. A lot of them had to face a lot of backlash to the landmark decisions they've received, whether from their peers or from their communities. And so highlighting those verdicts and highlighting those judges in particular really created a support system to these judges in order to encourage them in issuing other landmark decisions of that sort. And Tariq spoke how some judges were actually took the initiative themselves. That's absolutely true. And this is what the model defense succeeded in doing. The model defense was available for free on our website. It was distributed to most judges, to various lawyers, etc., in order to be used at the courthouse. And one of those judges actually used it without even us representing anyone in that particular case. He used the model defense to the letter and basically exonerated people who were being prosecuted before him based on Article 534. So it just goes to show how important this model defense also is. To add to what also Yumna said in terms of how to getting involved in movement lawyering, in addition to what I spoke about earlier in terms of actually getting to know the community, organizing sessions with the community, also what's very important, and I'm going to repeat that, is understanding the context. It's very important, especially if you were not living in Lebanon, especially if you are not part of the country, you don't know its history very well. It is absolutely super important to understand the legal context, the political context, and the social context, because otherwise you're going to be parachuting yourself inside the community trying to help. Again, I'm going to repeat, when we first started the job, whether it was me or Yumna, we came in with very good intentions, and then you're hit with realities, with the various realities of the community. It really teaches you how to understand the community and its concerns and to actually understand its narrative, because that would allow you later on to translate that narrative in the legal sphere, in the judicial sphere, to be able to, so that it is better understood in the judicial jargon, if I may say. One thing I would like to add, because Tariq spoke about it a couple of minutes ago, and I think it's important to highlight this. Tariq spoke about our collaboration in terms of labor rights. I'm going to use that occasion to also highlight what model defenses can do. We've worked on it in Lebanon, so to give a brief context, there's no legal a text that protects people from harassment, be it sexual harassment or moral harassment or what is referred to as bullying in the workplace. So what we did was use available laws as well as international laws that Lebanon is bound by to manufacture rights. And I think it's very important to speak about this because we've already done this before back in 2015. We organized a conference called The Manufacturing of Rights, and we explained how strategic litigations and model defenses also manufacture rights. We've done this either with queer rights in terms of actually creating a crime against homophobia, knowing that nothing basically criminalizes homophobia in Lebanon. The same thing happened regarding harassment, and using that to actually include more queer communities in the workplace by actually creating this model defense to defend someone who would be bullied, for instance, at the workplace. The model defense itself and strategic litigations themselves are part of this manufacturing of rights, and just shows when I speak about how legislators actually are not creating rights because it's a completely different system dwelling in a completely different sectarian and oligarchic context, how the judiciary and lawyers and activists and plaintiffs themselves can actually manufacture rights. And this is the sort of democracy that I was speaking about, that also Rita spoke about, where it is a novel form that has been transferred from parliament to the judicial platform.
Thank you so much. This is really a fantastic framework for people trying to understand and get involved with movement lawyering. And I think something that I see quite often, regardless of the countries we're talking about, even in the US, is that most, when we're talking about students and legal students, aren't really always provided with the tools, as we mentioned, when it comes to doing movement lawyering, and the framework of the way the education system within legal backgrounds, even mine, provides that sort of training, doesn't really provide that foundation framework that is required. So when you mentioned the rewiring that comes into it, when you want to do movement lawyering, is really fundamental. But also, I really love the points you're making about it, that it can't be separate from the political context. It needs to be in conjunction and understanding the political and social context that comes in. And I think, although it sounds like it's common sense, it often falls outside the line because of the way legal training is provided. So thank you for that framework. I'm going to jump to the final questions here. Although there were more questions, we're kind of running out of time. We have a question here that says, I know Helem in Legal Agenda and also worked to some extent outside of Lebanon, who also works in some extent outside Lebanon. I was wondering if there are any speakers here who could speak about more solidarity and movement work across the region and beyond. Let's start with Tarek about this sort of the work that you've done with regards to solidarity work beyond Lebanon and within the region.
Thank you, Afsana. I think there's the three questions that are remaining, all address sort of a global or sort of cross-border solidarity. So I'll speak to all three at the same time. I think we're entering an era whereby all problems are becoming global problems, and problems that specifically ignore borders, whether it's a virus or whether it's climate change or whether it's refugees. And it is imperative for us to start thinking of global platforms that we can solve these global crises, because we can't solve them individually. And LGBTQ rights are just sort of a part of that. Now, the real challenge has been to what sort of global platform or network can you create that's effective, given the nuances and the differences of the challenges that are facing the communities across the different countries in the world. I mean, even in the Middle East itself and in North Africa, each country has radically different challenges that it's facing on the ground. I personally think that the COVID-19 pandemic offers an opportunity with which to recognize that the world has changed and that we're going to be increasingly less equal, but increasingly more available digitally, which could provide avenues for us to explore global solidarity and work. And the way Hilm does a lot of its work is that we have networks across mostly global south and particularly regional organizations in which we share tactics, we share strategies in order to defend ourselves from the more common challenges that we face, including police brutality, including arbitrary arrest and detention, etc. And when it comes to global south and global north conversations, there really needs to be a convening and, as my colleague said, a thorough understanding of the challenges and the issues that we are each facing. What we're witnessing in the world today, particularly in Europe and the United States, is that history is cyclical, and that it doesn't matter if a Supreme Court passes a law, at some point, there is always somebody who's going to be trying to work to take your rights away. You can never put your suitcase down. You always have to think about constantly defending the gains that you've had. And we're right in it in Lebanon right now. All of our work right now is geared towards not losing all that we've gained over the past 20 years, not to go back to where we were when the police would arbitrarily arrest and just invade our homes and our institutions. So it's not like the global north is ahead in some sort of linear trajectory. It is much more complicated than that. So I'm hoping that that these sort of global spaces start opening up to these conversations, and we start listening and understanding what's really going on, and sharing resources, sharing expertise in order to solve these problems. Because as of now, we cannot afford to be isolated, because our adversaries are talking to one another, they're coordinating, they're much better funded, much better organized, and we have to be the same.
I wanted to jump to Yumna if you wanted to add anything here as well.
Yes, I just wanted to say regarding this question that, of course, we know that, I mean, we as Legal Agenda have another, have been expanding. We have correspondents in all of the Arab world, and we also have a Tunis team. So we have individual correspondents in a lot of places, and we have a team that works from Tunisia, and they also publish from Tunisia, and they organize seminars and lobby around these issues. So yes, we do have this kind of collaborative work, and we do not just work in Lebanon, we work in the region.
Karim?
I would like to answer this question from a different perspective. We've already collaborated with other global partners from the Global South when it came to Article 534 per se, because a lot of those countries were former colonies. And there's something that was mentioned a little bit earlier when we tried to explain to judges that these are not Western values we're defending. In fact, Article 534 is a Western value. It was established in Lebanon in the 30s during the French Mandate, back when France was governed by the Vichy government, who in itself was inspired by the Nazi regime. So Article 534 is really the product of that, and it was imposed in a country where texts before that didn't exist criminalizing homosexuality per se. So what we've done is collaborate with other global South former colonies that have similar texts, whether they were French colonies or British colonies. So it's all contra naturam legal text. So it's kernel conjunctions against the order of nature. And we started sharing jurisprudence basically with those countries. We worked with Kenya, with India. They've used landmark rulings, we've won. We've used landmark rulings, they've won. And so we helped each other in that sense, in a way. So that's also another form to basically develop this global solidarity, especially in a very targeted way when related to articles like Article 534.
Fantastic, thank you so much. And I think even within the region, the states like Iran that don't have the laws based on ex-colonial rule, they still adapt it based on the laws from the region. So that becomes such a fundamental aspect. And thankfully, our colleagues are putting in links as we speak that are very useful here. I wanted to say also that it's just been wonderful to learn from all of you and work with all of you throughout this time, and continue to learn from all of you. And when it comes to this international context too, I've just seen firsthand, when it comes to my own sort of focus when it comes to digital evidence, how important it becomes for the different countries we're looking at to see what's happening when it comes to these sort of nuances as well in other places like Lebanon, whether it's the lawyers in Egypt become very fascinated with how your strategies are developed and vice versa. So I'm so glad to hear that these solidarity movements and strategy exchanges are already happening, and I'm looking forward to see how they continue. Anyway, we have run out of time, and I'm going to wrap up here. I just want to thank all three of you. This was just such an incredible panel, and we've recorded it, so everyone needs to be listening to it, and we'll be sharing it widely. Again, I would like to thank our audience for sticking with us. It's been an hour and a half now, although it's passed very quickly. And to thank our hosts one more time who made this possible and supported it. The program on the law and society in the Muslim world, the Office of the Clinical and Pro Bono Programs, and the LGBTQ plus clinic at Harvard Law School. Again, thank you to those behind the scenes, making things run smoothly, sending us prompts, and making sure that we're kind of in line with what's happening and organizing everything. Thank you again. And Tariq, Yumna, Kareem, always a pleasure. And I hope to speak to you soon. And I hope you've also had a great time. Thank you so much for being here today.
Thank you, Afsane. As usual, you were superb. And it's a pleasure actually to work with you.
Thank you.
I agree. Thank you so much.
I agree with that.
Thank you all. Thank you. Take care and have a good evening in Lebanon, and good day and good afternoon wherever everyone else is. Ciao. Bye-bye. Bye.
Bye-bye. Thank you.